From the nation's capital, the American Enterprise Institute for Public Policy Research presents Public Policy Forums, a series of programs featuring the nation's top authorities presenting their differing views on the vital issues which confront us. Today's topic, an imperial judiciary, fact or myth?
For more than a decade, there have been complaints from lawyers, judges, and defendants that lengthy delays are sabotaging the fairness of the American court system. It's not unusual, especially in state and local courts, to find it takes as long as 5 or perhaps 6 years for some courts to decide cases because court schedules are so overcrowded. Attorneys for defendants say that such delays are unconscionable, that long delays often jeopardize the right of their client defendants to a quick, fair trial, which they say makes those delays unconstitutional. As they put it, justice delayed amounts to injustice. What are the real causes of these delays? Is it true that so-called imperial judges are a major cause? Are judges taking on so many new kinds of cases that they don't have time for the traditional ones? What, in fact, is an imperial judiciary? Should there be restraints, for example, on judicial activism as the legal system becomes more and more involved in such things as protection of minority rights, the political process, and in overseeing education and social services? What is the proper role that the courts should play in today's changing society? Welcome to another Public Policy Forum presented by AEI, the American Enterprise Institute, a nonprofit, nonpartisan research and education organization. This roundtable discussion will present the topic, an imperial judiciary, fact or myth. Appearing on today's panel are Abram Shays, who is Felix Frankfurter Professor of Law at Harvard. He has taught at Harvard since 1955, except for a 3-year period during the Kennedy and Johnson administrations when he was legal advisor to the State Department. Antonin Scalia, who is also a law professor at the University of Chicago. Professor Scalia interrupted his teaching to serve as Assistant Attorney General in the Office of Legal Counsel during the Ford administration. Professor Scalia is presently an adjunct scholar at AEI, having been a visiting AEI Fellow in 1977. Lawrence Silberman, also an attorney, is former U.S. Ambassador to Yugoslavia, served as Deputy Attorney General and as Undersecretary of Labor during the Nixon and Ford administrations. He is a senior fellow at the American Enterprise Institute. Ira Glasser is Executive Director of the American Civil Liberties Union. He has also served as head of the New York Civil Liberties Union. Mr. Glasser was editor of a magazine called Current before joining the New York Civil Liberties Organization. John Charles Daly is moderator of today's roundtable discussion. Mr. Daly is a former news correspondent and commentator for CBS News and ABC News. He is a former ABC Network Vice President and once headed the Voice of America. Now, here is Mr. Daly.
This Public Policy Forum, part of a series presented by the American Enterprise Institute, is concerned with the basic element of our concept of government, the checks and balances established in the Constitution among the executive, legislative, and judicial branches of government. Our subject, an imperial judiciary, fact or myth. Over 2 centuries, charges of abuse of power have fallen on executive, legislative, and judicial branches seriatim. But with the exception of the catastrophic explosion of civil war, imbalance has been redressed by the inexorable impact of the Constitution's checks and balances and by the passage of time. In this era of explosive change, the judiciary is the target, with the legislature and the executive often at cross purposes, with enthusiastic special interest the ethic of the day, with uncertain leadership and the public poll a dominant yardstick in decision-making. The courts have become the stage upon which the day-to-day drama of the American experiment is played. The charge is now made that the courts function too broadly and plan and manage a reordering of the economic, social, and political life of the nation. As earlier we heard cries of an imperial presidency, we now hear of an imperial judiciary. Ambassador Silberman, yours is a strong voice charging that we are trying to deal with too many of our problems through courts and lawyers. Do you feel that we have an imperial judiciary, and what does it mean?
Well, I should answer the second question first. What it means is that one branch of our government, in this case the judiciary, is seeking successfully power at the expense of the other two branches, and to an extent at the expense of society as a whole, as of the private sector. And I do believe we do, in that sense, have an imperial judiciary. It seeks power, and it has, in the last 25 or 30 years, gained a great deal of power. But beyond that, it is important to note that it is given much too much power.
All right, Mr. Glasser, as Executive Director of the American Civil Liberties Union, the courts are your primary field of battle. Do you find empire therein?
No, I think that basically the courts are a reactive institution. They're the only branch of government which cannot by itself initiate action, and I think therefore they are necessarily weaker and more limited in their exercise of power than either of the other two branches. I think they are the only institution that is charged with adjudicating claims against the majority and is charged with limiting the power of the majority. And in that respect, I think it is the only institution that protects our liberty by setting those limits on the other two branches. That it may, in one or another instance, exceed those limits itself is undoubted. But I think that as an institutional question, I find the charge basically derivative of a dissatisfaction with the merits of decisions and not supportable as a procedural matter.
Professor Scalia, you have noted that between 1960 and 1975, the number of cases in the federal district courts doubled, the number of cases in the appellate courts quadrupled, the number of cases in the Supreme Court doubled. Does this automatically mean the courts will have a very important impact, whether they wish it or not?
No, not the kind of impact that concerns me. It isn't a question of how many cases come before them. It's a question of what types of issues they decide. For example, do they or do they not decide that the citizens of California can have a referendum on the desirability of open housing laws? Do they or do they not decide whether schools should be funded on a local basis so that varying districts can have schools with varying degrees of excellence? Do they or do they not decide that the not only a possibly desirable but the constitutionally mandated way to achieve integration in society is to bus students from one school or another? It's the issues that they've chosen to decide, not the number of cases that come before them.
All right, Professor Shays, you have written, over the last 2 decades, courts have assumed responsibility for desegregating school systems, reapportioning legislatures, regulating employment practices of major companies, supervising land use planning of municipalities, directing credit practices of banks and credit card companies, monitoring environmental quality, and even managing mental institutions and prison systems. Now, in view of the laws and regulations pouring out of the legislatures and the government agencies in the last 2 decades, did the courts have a choice?
Well, I guess you're right that in the implication that a growth in judicial visibility, at least, is one of the afflictions and diseases of modern civilization. If you take modern civilization, you're going to have to take the good with the bad, and to me, it seems almost inevitable, in our country at least, with the historic tradition of judicial settlement, that the judicial role is going to expand. The government has expanded, the legislative role has expanded, the executive role has expanded, and it seems to me only really quite obvious that the judicial role would expand with it. The alternative to that is, as Mr. Glasser said, unchecked legislative or executive power, and this country has never operated on that premise.
Abe, I guess that shows just to what degree we come at this thing from opposite ends, because I took Mr. Daly's implication to be just the opposite. That is, to be that since we do have such active legislatures nowadays that devote their attention in some detail to all sorts of things, isn't it possible for the judiciary to rely upon that process, perhaps to an even greater degree than it used to in the past? Isn't somehow the need for judicial involvement, in one respect at least, less than what it used to be?
Sometimes in detail, Nino, and sometimes not. The Internal Revenue Code is an example of the legislature operating in detail. The antitrust laws is an example of the legislature operating at large and telling the courts, in effect, you can't, laying down a rule that says corporations shall not combine unreasonably in restraint of trade, and leaving the courts to figure it out. Now, that too is a rather general phenomenon in Western countries. That is the phenomenon of legislatures acting to lay out broad lines of general policy and leaving it to others, in other countries mostly bureaucrats, to work out the details. In our country, a combination of bureaucrats, administrative agencies, and courts to fill in the details.
Well, the question is not so much, it seems to me, the scope or the quantity of issues, as Nino said earlier, that are put to the judiciary. The question is really the quality. And therefore, it would seem to me, the way you put it, Abe, that you would expect the judiciary to grow in business as the other branches grow with the expansion of the government is a bit misleading, because what has happened is that more of the fundamental policy making has shifted to the judiciary than was ever true before. That is to say, let's assume a steady rate of growth of all three branches in terms of the amount of material they have before. It would be my argument, and I think Nino's too, that more of the fundamental policy, which in a democratic process, as our basic premise, is put to the people, more of the fundamental policy has shifted to the judiciary, and therefore the legislatures, the Congress, and indeed even the presidency weakens and atrophies.
Let me suggest, though, another distinction that I think sheds some light on that problem, and I think that as a development that is unquestionably true. Nino made a point before that it is not the number of decisions that concerns him, but the kinds of decisions. Well, there's another distinction to make. It's not so much the kinds of decisions as to who has rights in various institutions, but what happens once you adjudicate that those rights exist, what's the remedy? Most of what you would call, I think, the detailed management of the institutions that flows from judicial decisions flows at the remedy stage. The way that arises, from my point of view, and I operate, as you understand, only in the area of rights, what happens is that there is a claim of right. The claim may be on behalf of a mental patient at a mental hospital. If that claim is that he shouldn't be there against his will because he's committed no crime, if the court rules in his favor, that's the end of it. The state doesn't have the power to hold him, and it releases him. But that's not what the courts have ruled. What the courts have ruled is that he can be incarcerated for his own good, so long as the quid pro quo is given by the state. That is, if he's being incarcerated not because he is dangerous or committed a crime, but because he needs treatment, then it must, as a matter of right, provide that treatment. Then he goes into the mental hospital, and what he gets is custody and brutality. So he makes a claim in the court that if you want to continue to hold me, I have a right to treatment. If the decision is that he does have that right, then the question is, how can you mandate it? The court orders the hospital to provide it. Three months later, the patient is back in there with his lawyer saying, they're not listening. The attempt for the court to mandate the remedy, and this is true in prison cases, in mental hospital cases, in foster care, children's rights cases. It's also true in school desegregation. The frustration and the problem we're dealing with arises at the point of remedy, where the majoritarian system, the executive branch, the legislative branch, public agencies, do not respond in any self-executing way to the initial court order saying that there is a right. So what you're confronted with is a right without a remedy, and the court is then involved, and the lawyers on both sides are involved, in a kind of an ongoing external administration of those agencies. Now, I concede that that's a real problem, but to simply say that the courts shouldn't be involved in that is to cede all of that to the legislatures and to simply assume, because I think that that's the fact, that there will be rights, there won't be remedies, and therefore I think in the end there won't be rights.
What the argument is about in most of these cases, is not whether there's a right or not, but whether in fact the right has been adequately observed or not. And the courts are increasingly willing to set themselves up as the judges of that fact. That is one source of the difficulty. A second source is simply you can speak very facilely of rights. Where are there rights and where are there not? That is another judgment that the courts have been increasingly willing to arrogate to themselves. In the abortion situation, for example, whether indeed the right that exists is the right of the woman who wants an abortion to have one, or the right of the unborn child not to be aborted. Who knows? In the past, that was considered to be a societal decision which would be made through the democratic process. But now the courts have shown themselves willing to make that decision for us. That's, I think, the major objection that most people have with the direction in which the courts are now going, and the major reason why many people feel that it is indeed an imperial judiciary.
Ambassador Silberman?
Now, clearly, democratic processes cannot exist without the recognition of certain fundamental rights. Without it, a democracy is impossible. You must protect in a democracy the right of dissent. That's what a democracy is all about, a system that legitimates dissent. But going back to the point Nino was making, once you start debasing this notion of rights, once it becomes a tag word for everybody's claim, then it really becomes simply a way of transferring particular controversies from the representative processes, from the legislatures, etc., to the legal process. Because when you say you have a right, that means I have a superior moral claim against the majority. And in a democratic process, you have to worry about that, because it's conceptually quite possible that that will grow and grow and grow, and indeed some of us believe that it is growing to that point, where you're robbing from the political process as well as from the private process.
Well, I think it's important to make the distinction between courts operating under the Constitution, which Nino was talking about, and courts operating under statutes. It may well be true that, in your view, it's unwise for Congress to give authority to courts to work out the details of a general policy embodied in a statute. But at least you can't say it's undemocratic. It's the Congress who has decided that it's the courts who are supposed to do this.
Well, one
and
can say
presumably they've decided it on the basis of some feeling about the value of judicial development, let's say, of anti-discrimination laws, Title VII cases. Here you have a situation which Congress has asked the courts to work out the meaning of that general legislative mandate. Now, that's not something that's confined to this country.
It wouldn't be the first time in history that a democratic process or a democratic government was involved in its own atrophy or even destruction. In fact, the truth of the matter is that Congress increasingly delegates more and more authority to the judiciary and to the regulatory agencies in a combination, because it has increasingly been intimidated by the judiciary.
Well, intimidated. Part of the problem, as I say, this isn't something that's unique to this country. You find the problem, the phenomenon of delegated legislation in every Western democracy.
Yes, but this is the only industrial democracy with a tripartite structure, with an absolute division between the executive and legislative branches and the judiciary. And that's very important, because the founders of our democracy intended to make the accretion of government power difficult. And what has happened by virtue of this enormous growth in the legal process and the judiciary process is what we have seen is a way in which a certain segment of our society has sought to circumvent the limitations of the Constitution and therefore enormously expand governmental power.
Well, but you see, I think as generalities, there's little that I would have to disagree with you. The problem is that I don't think that this issue is illuminated by talking in generalities. When you said a moment ago that The problem is that rights are being debased because everybody who has a claim of any kind calls it a right, tries to get it adjudicated. The courts are reaching out and becoming accomplices to that process, and the whole concept of rights is getting debased. Now, there is a good deal of that. I mean, I see it every day in my office. I guarantee you that 95 out of every 100 people who come to the Civil Liberties Union looking for help because something is going wrong in their lives and they think their rights are being violated, and they get very angry when we tell them that's not a constitutional right.
But you tell them come back next week, it might be.
That's right. Why wait to the last minute? We're working on it. And the real problem is that I believe that if the word right has any legal meaning as a functional term in our system, it frequently denotes something which must be immune from being overridden by the majority. I mean, that is my day-to-day definition of a right. I think you would not disagree with that.
We'd all buy that.
So what we're talking about, then, is not really a general disagreement. I mean, we each can state this in general terms which the other will find it hard to disagree with. I know where we will disagree is that our definition of particular rights will differ. And that's what I meant at the beginning by saying that I thought that this procedural argument about the overreaching of the courts was at bottom a disagreement that we had about the merits.
Well, there are two aspects, as I think Abe pointed out. There is the function of the court's expansion, which is related to their constitutional function of deciding what are constitutional rights. And much of what they've done is in that area, and I think they've gone too far in that area, finding rights where the society never believed they existed before, and I don't know where they plucked them from, except out of their own minds. There's an entirely separate area, though, which I think might be larger, and that is not the creation of rights from the Constitution, but rather the interpretation of legislation that has been enacted by mainly the federal Congress. I could not disagree more with Professor Shea's notion that it must be democratic if it's been enacted by a democratic Congress. The courts used to have a doctrine that the Congress could not delegate authority beyond a certain degree because that would be unconstitutional to cede away.
There's only
now,
one
wait a minute.
case that says
that's right. That's right. But the concept is a difficult one to enforce. But let's talk about specifics. The Congress decides to pass a law saying there shall be no sex discrimination in universities, any university programs. Why do you think the Congress is not more specific? The simple reason is that they realize that the democratic process in that context puts too much heat on them. By passing a law like that, everyone applauds. Who is in favor of sex discrimination in universities? Please stand up. No one, certainly.
You can all sit down again.
But
You've got to be quick, Nino, or you missed them.
Now, the Congress certainly knew when that law was passed that there are a lot of real political questions involved in that decision, which should be decided through the democratic process. What does sex discrimination mean? Does it mean that major universities can't have a football program in which they spend enormously more money on football teams than they do on their women's sports programs? Many other issues like that. Congress chose not to address it, and they kicked the ball over to the courts because it's easy. But that is not democracy.
But, Nino, two things. First of all, the Congress remains there and can change it if it doesn't like it. We had a situation just this last year where Congress did the opposite. It said, never, never, never kill an endangered species, no matter what. So the court did exactly what Congress said. It said, we won't build this dam because we've got to save the snail darter. And the Congress decided that that wasn't really what it meant and changed it.
I am just an underread layman, but the imperial concept to me was reaching out and grabbing, and yet much of what I've heard tonight says that this has all been shoved on the courts.
No, I would disagree with that. I think the court has reached and reached and reached. And unfortunately, the more the court reaches, the more the Congress gives it. That's why we have discussed it in the way we have. In other words, the more the Congress sees that the judiciary is willing to take on what we used to refer to in law schools some 20 years ago as political questions to be eschewed. There used to be a doctrine in the law schools, there used to be a doctrine in the courts, that in a democracy the courts should try to avoid political questions. By that we meant basic policy issues that are more suitable for a legislature.
I think what you're really saying, and I don't want to charge you, Nino, with having made a concession a moment ago, but when you focused in on Congress and said that Congress is not passing specific enough statutes, Congress is enacting laws or failing to enact laws in such a fashion as to thrust the adjudication of claims that individuals make into the courts, I think that was closer to the truth. See, I think the problem with thinking about the judiciary in the same imperial terms as you think about the executive and the legislature, is a little bit of an exercise in nominalism, a little bit of a cute trick by using the word imperial.
Well, it was Nathan Glazer that first used it, and he used it at a time in a public interest article, and he used it at a time when much of the intelligentsia in this country was focusing probably falsely on what they saw to be an imperial presidency, at the very time the presidency was declining in power. And Glazer came along and said, hey, wait a minute, there's another branch of government that is arrogating to itself enormous power to define, to elaborate, to create rights, and to administer whole segments of our economy,
but that
hospitals, schools.
Yeah, but that happened exactly at the time that Glazer began to change his position on the merits, and that's what I'm continuing to say. See, the problem is that I think that the power of the judiciary to assume an empire unto itself is intrinsically limited in a way that the legislature and the executive is not, because it cannot initiate action. And I've been around legislatures enough to know that they get themselves off the hook all the time by passing laws that and letting the courts worry about it. I mean, if you prowl the halls, you'll hear them say that. That's no good. But the fact of the matter is that once they pass the statute, what is somebody with a claim under that statute supposed to do if they pass a statute saying no sex discrimination at universities, and then a woman wants to try out for the badminton team? Let's make it a little bit harder so it doesn't involve personal contact. And the university says, no, you can't do that, we just don't have mixed sports. And the woman says, but look at the statute. And the administrator says, the statute doesn't apply. Now, where is she supposed to go if not to the courts?
She has to go to the courts. I have no quarrel with you. But I am not particularly I am not particularly concerned whether the courts put the crown on their own head in Napoleonic fashion, or whether somebody else conferred it upon them. My only point is that the crown is there, partly put there by the legislature, partly arrogated by the court itself, and let's not forget to blame the executive branch. Because in fact, what the executive has been doing for many years is going up to the Hill and seeking broad statutes, because they were under the impression that the more vague the statute, the more discretion I have. What they have found in recent years, however, is that the courts are suddenly beginning to pretend that these absolutely meaningless phrases have meaning. And so instead of arrogating discretion to the executive, they find to their horror that the discretion is sucked right over into the courts. That's what's been happening. So I think you can blame everybody. You can blame the Congress, you can blame the executive, you can blame the courts. I don't care who you blame, I just don't want the crown there.
I think it is true, in a sense, that one of the occasions for an apparent expansion of judicial authority has been in the delegitimization of Congress and the executive over the past few years. It still is not true that Congress is weak or powerless, or that the executive is weak or powerless. We do have a very strong interaction among all those branches and the electorate as well. The courts have never been able to sustain a policy against the significant resistance or non-acquiescence of the public.
That's not true. You have one right now that's been going on for many years on busing. You take polls, if you came down from Mars and looked at the United States and saw that the vast majority of American people, black and white, oppose busing, forced busing, you would say, well, my gosh, if this is a democratic society and this is such a dubious question and it's decided in such a fashion against majority will, how can you justify it? So I'm not sure that's really true.
Well,
and I'd like to go back to a point that you made.
I think that factual assertion is nonsense.
That's right.
You mean the polls?
No, I mean the fact that most people oppose busing. Nobody opposes busing in this country except people who oppose busing for the purposes of integration. 97%.
No, mothers
No, wait a minute,
oppose
wait a minute.
forced
Forced
busing is what I said.
Forced busing is what is
Let
what
me-
we're
but they
taking a poll on.
don't. But they don't oppose it because they're on a bus. They oppose it because of where the bus is going. Now you can disagree with that,
Well, I
but
haven't-
that's not the same thing as saying they oppose busing. 97% of
You
the
could say the same
busing.
thing about a person who's kidnapped. I mean, what is that? You know.
No, you could say it. I
don't
can't
mind-
say that.
I don't mind being in the car. I just care about where the car's going.
That's right. Well, that's exactly right. Kids get bused to school. Kids get bused to school that they don't choose all the time, miles away from where they live, and nobody ever objects. And you see, what's happening
Well,
now
wait a minute.
is
The
what I
important
suggested
point-
from the
the important point is
beginning.
not
We
what-
disagree about the issues.
No,
we
no,
don't
no.
disagree about the
No.
procedures.
The important point here is not why people are upset. It is the fact that they disagree. And the fact is we live in a society in which majority rule, with some limited exceptions, is supposed to obtain. And yet here we have this major question on which all of our political institutions, and certainly all of our people, come out one way, and our judicial system comes out the other way, in absolute defiance and in continual defiance. So I go to the
But
point
that's
that you make-
proper if you're dealing with rights, isn't it?
I know. One man's rights is another man's kidnapping, is what he said.
Could we get at you know, the fundamental issue of you say the majority of? We have had several elections since this became a major issue. Can you think of any number of legislators in either house who were not returned to office because their position on busing was that it was necessary and right?
As a matter of fact, in the last few elections, you probably couldn't, because there are very few legislators whose positions are not consistent with the way I expressed it.
But the Congress has never passed a bill limiting the remedy to its constitutional.
In part, Abe, because the argument has been made it would be unconstitutional to do so.
And that is the major thing that
Yes.
they themselves will assert, if you ask them why they haven't done it, for not passing a statute, because
But-
they've been persuaded that there is some constitutional rights that the courts cannot be interfered with in
Yes,
this
there's
respect.
a certain mystique about the judiciary in this
Well,
country, and a false mystique at that. Indeed, a mystique
Those are the
which
best
was...
kinds of mistakes.
Yes, of course. It was a mystique that was more justifiable some 20, 30, 40 years ago, when at the same time there was a doctrine of judicial self-restraint. After all, in our law schools, in our legal periodicals, and on the judicial decisions itself, 30 years ago there was a great deal of attention to the old Frankfurtian view.
Well, Larry, I clerked for Justice Frankfurter, and he sure was an advocate of judicial self-restraint when he was in the minority. The advocates of judicial self-restraint mostly have been, as you say, in the academies on the one hand, and on the other, the people that were losing. I think Ira is correct in that.
I don't agree with that.
It is quite interesting to see, for example, that in the 20s and 30s, the liberals were all for judicial self-restraint, and the conservatives were all for judicial activism, because the court was coming down on the conservative side. Now, the liberals don't care so much about judicial self-restraint, and that's all the conservatives are talking about. The concern here is far more with whose ox is gored than with kind of broad questions of political philosophy.
So you have written, but indeed, if one takes it to its logical extreme, there really is no restraint whatsoever on the judiciary, and we might as well just give up and allow them to make all the important fundamental policy decisions in our society, and you can't possibly mean that.
No.
Abe, if what you're saying is that the portion of society that is most being harmed by the activism is the portion that is likely to squeal the loudest, it's certainly
Of
true.
course.
But I don't see how it says anything about the truth or falsity of the fact that the court should not be activist. They were wrong when they did it in the 20s, and they're wrong when they do it today.
Well, it seems to me that historically, at least, and I have tried to develop that at some length, historically, at least, that's not true. The court has been active since John Marshall decided Marbury and Madison, or upheld the Bank of the United States, or since the court outlawed legal tender or the income tax. The court has been a part of the political process, was designed to be a part of the political process from the beginning. That's what Article 3 of the Constitution means. As you said, Larry, we're the only country that has a judiciary as part of the government.
Yes, but in all fairness, Abe, the judiciary is going to be less active if they worry about it, and if law professors teach them to worry about it, and if indeed law students are taught to worry about the legal process and the judiciary process expanding too much because it is a threat to democracy. Granted, it's never going to be perfect. You're never going to have a clear line between that which the judiciary can do and that which it cannot do. But nonetheless, what is important is we have lost the judicial humility. We have lost the sense of self-restraint. And I think
Larry,
the law professors have added to it.
you haven't been talking to the judges I've been talking about who
Humble judges?
On this question of arrogation. Yes, humble judges. You talked to Judge Lasker in New York, or many of them. Talk to Frank Johnson in Alabama. Those people are not people who have reached out and grabbed power. Those people are people who have seen not just gray area violations of rights. Those people they're people who have walked into mental institutions and prisons and seen people being tortured, having hoses stuck down their throats, things like that. Is a judge to sit by and say, well, that's what the majority says?
You know, there's an old aphorism which it seems to me is relevant here. If you hang out your shingle and your service is free, you'll get all the business. And that's what the judiciary has done. There were doctrines for many years in this country which limited judicial relief. You had to have standing, which is a legal word where it really means you had to be hurt. You had to be hurt before you could go into court. You couldn't go into court because you didn't like what the government was doing generally. You didn't like where your tax monies were going. And that doctrine for many years prevented the judiciary from being dragged into all sorts of policy questions. Well, really, that doctrine eroded only in our lifetime.
But Larry...
Well, look, I said at the beginning that I thought we had to talk about specific issues and not about generalities. There was, in the early 70s, a place in New York City called Willowbrook, which is a school for the mentally retarded. You walked in there and you found kids with maggots in their flesh underneath casts that had not been attended for months. You found 100% of the kids admitted in that school getting hepatitis within 6 months. You found daily, weekly, preventable deaths from kids choking for a very simple reason, because there wasn't a resuscitator on each floor of that hospital. One of the elements of the 80-page single-spaced order that a conservative judge like Orrin Judd in New York issued, not because he became persuaded by lawyers' slick arguments in court, but because he went to Willowbrook and smelled the place. One of the details was that there had to be a resuscitator on every floor. And that decision was attacked in the newspapers by some people for, among other things, including frills and details. And that was one of them that they mentioned. Because if you don't understand the relationship of having a resuscitator on every floor and the preventable deaths that happen to retarded kids when they're being force-fed by too few people and they're choking because they can't coordinate themselves, then you don't understand what the issue is about. If you went down the 80 pages of the single space, you would find details that you wouldn't ever believe could come out of a court. I don't even believe they could come out of a legislature. It's the kind of thing you would normally expect to come out of the administration. I agree with you completely. It should have, years ago, decades ago. But I got to tell you something. It didn't, and people died. It didn't, and people had maggots in their flesh. It didn't, and people got hepatitis. And what happened, even after the court order, is that the judge, the trouble with talking about the courts as a powerful instrument, they made the court order. It was terrific. The lawyers all thought they won. There was a story on the front page of the Times. And guess what happened the next day, the next week, the next month, the next year? Now, years later, nothing.
Well,
there was no enforcement.
Maybe that suggests that it's a fundamental mistake.
It suggests, no, it doesn't suggest that it's a mistake. It suggests the problem. The problem is that I agree that these issues should not be thrust into the courts. The courts have no capacity to deal with them. But the rights that are being violated in some of these institutions are gross beyond belief. And the administrative, executive, and legislative branches that should be dealing with them in detail don't.
Yeah, but
and
all
when
right,
you
let's-
and then you go to the court and you say, do something about it, and they do, and then it's not enforced, and they try to enforce it through contempt remedies, and it creates both in the courts and the lawyers a kind of an external administration, which is nonsense. But the remedy to that is not that the courts are arrogating power. The problem is that the alternative is to let those people rot, because the administration will never do anything about it.
I think you're right, that the areas of our agreement are probably much greater than the dispute might indicate. We have no quarrel, I think, where the right in question, if it's being enforced through the Constitution, is one as to which the whole society has no question. Forcing hoses down people's throats, inmates deteriorating physically because of grossly inadequate treatment such as you've just described. There's no question that the society holds those values high, and one does not have an objection to the courts enforcing those rights. But the courts have enforced other rights, so-called, which there is no societal agreement upon. In the abortion cases, at one extreme, and to descend from the sublime to the ridiculous school dress codes and things of that sort. There is no national consensus about that, and there never has been.
But
the
Nino-
courts have no business being there.
But Nino-
Now just let me get the whole thing out. That's one of the problems. They're focusing upon rights and calling rights things which we don't all agree about. The things we agree about, no quarrel. The second problem is the issue of standing, which Larry has described. It essentially means that you have been harmed yourself. Since you've given a case history, let me give a case history about a case in which the court has found adequate standing to exist. The well-known Scrap case, which involved a decision by the Interstate Commerce Commission not to suspend a railroad freight increase of 2.5%. That was challenged in the courts by a public interest group who claimed that they were being hurt, substantially affected themselves on this ground, that they used the national parks and that the 2.5% freight increase would cause the cost of recyclable goods to increase, wherefore more beer bottles and non-recyclable goods would be found lying about in the national parks. Now, can one seriously quantify the individual interest that is constituted by the possibility of seeing that number of beer bottles that would be attributed to a 2.5% freight increase by the railroads? It boggles the mind. But the court said, well, that's enough for you to bring your cause before us, and we will decide it. John Marshall would have turned over in his grave, Abe.
Nino, let's go back to the first point. You say we can enforce rights as to which there's a consensus, but not these far-out rights. It's interesting to me that the first free speech case under the United States Constitution occurred when? 1918, after 150 years. So the court has always, I think, been, and necessarily must be, on the, in one sense, the frontier of rights, because the people who are making these claims, who are sensitized to the deprivations, go to the courts. That is their refuge, number one. Number two, you talk about standing. Well, there again, I'm interested that not only in this country, but to take this country alone, the Congress in the Clean Air and Clean Water Acts has enacted citizen standing. It has said any citizen, whether hurt or not, may sue to enforce these things. Why? Because the Congress is interested in getting the rules enforced. It doesn't believe, or maybe it doesn't appropriate enough for the governmental enforcement agencies to do so. It enlists citizens to enforce these rules. So in the same area of environmental protection, the Congress itself has said any citizen, or in Freedom of Information Act, any person.
It's a mistake. I've said before the Congress should not say that. When the Congress says that, what it amounts to saying is that every citizen has a right, and you can call it that if you want, a right to have his government act justly, fairly, and efficiently. Once you confer that kind of a right and you call it a judicially enforceable right, then everybody can go into the courts whenever there's anything wrong in any agency activity. So if the ICC allows a 2.5% freight increase that you don't like, suddenly that becomes a judicial question at your instance, even though you have not been substantially affected by it. This is precisely what has caused a vast majority of issues to be decided in the courts.
And what
It
is
should not be
important,
there.
and what is important, and we have not focused on, is that judges, for the most part in this country, are not elected. Indeed, they're insulated from the political process. Therefore, going back to your original point, Ira, I would say that we have to worry more about an imperial judiciary than we do about an imperial presidency or an imperial Congress, because we can throw the rascals out in the executive branch or in the Congress. We can't throw them out of the judiciary,
No, but we can
as
ignore
we
them.
just saw in California.
Yeah, I suggest that we've created a very broad base from which to receive questions from our friends and guests in the audience. And it's time for the question and answer session, please.
Yes.
sir.
David Lichtenstein, General Counsel, Accuracy in Media. If my memory serves me correctly, I heard a very distinguished professor at Harvard Law School, who subsequently became a justice of the Supreme Court, say that the beginning of wisdom about constitutional law is that the United States Supreme Court makes political decisions. Now, that's a rather ambiguous term. As a matter of fact, several speakers have used the phrase policy decisions. And I'd like to ask Mr. Scalia or Mr. Silberman, could you possibly define what restrictions and what line you would draw between a policy decision and the legitimate area within which a Supreme Court in our constitutional system may operate?
Would you like to start, Professor Scalia?
Yeah, it's an awfully big question. Needless to say, there's plenty of room for the Supreme Court to make important social decisions, if that's what you mean by political decisions, within my constellation of things. Where do I draw the line? I suppose I draw the line at the point where, in the rights area, constitutional rights, the court plucks out of the air a principle of action which is neither felt by a majority of the people within the country today to be necessary, nor was felt by the people at any time in our history to be necessary. Now, the examples of those that I'd give would be, for example, the court's decisions in capital punishment. There is simply no historical justification for that, nor was there any way in which the court would say, well, we're expressing a modern consensus of the society. It's just not true. And I think you could say the same thing about the abortion decisions. Now, that's really telling you what a proper political decision by the court is not. It's very hard to tell you what it is. It's short of making fundamental social determinations that ought to be made by the democratic process and that the society has not yet arrived at. I think the court has done that in a number of recent cases. As for the busing cases, there was no need for the court to say that granted that school desegregation is bad, the inevitable remedy for unlawful segregation is busing. There are many other remedies that might have been applied. It was not necessary for the courts to step in and say, this is what must be done, especially in the teeth of an apparent societal determination that the costs are too high in terms of other values of the society.
Mr. Glasser?
Yeah, well, I think the problem with continuing to refer to what the consensus of society is, is that the court is charged with making decisions precisely on behalf of minorities and against the consensus. That's usually why the minorities are in there in the first place making claims. And one of the problems that you have is that if you had left it to the consensus in 1954, the court would have been disabled from ruling in the school desegregation case. On virtually every major right, especially every major breakthrough of a right, the court is always out at the edge of the frontier, is always acting as a limit on majority rule. In fact, the well-worn phrase tyranny of the majority is precisely in some respects what the Bill of Rights is supposed to deal with as a hedge against and what the courts are charged with enforcing.
But I'm not talking about just a temporary consensus. I'm not saying the court has to always go along with the consensus of the day. If the court finds that the traditional consensus of the society, the constitutional substratum of the society is against the daily consensus, if that's the case, then the court overrides today on the basis of our historical beliefs as a society. I can understand that. But I can't understand it, as I said, when neither history nor current social perception demands that something be called unlawful, that the court can somehow find it to be so.
Both were against school desegregation, though, in 1954.
Let me respond to the question, which I think is a very good one and a very tough one. I do not believe what has almost been an assumption of several of our panelists here today, that the judiciary will always be involved in political decisions, and we should lay back and enjoy it. I do think that, in fact, and would concede that certain political issues have always slipped into the judicial process and always will. It's very hard to try to excise them from it. But I do believe that in a democracy where judges are appointed and have such enormous potential power, that it is crucial that they constantly struggle with doctrine, which is self-limiting, and that they constantly seek a way of trying to eschew political or policy issues. Now, when we were in law school, we were taught a policy issue is sort of the opposite from reasoned elaboration, the kind of question of which there are a number of choices and which do not follow from a given logical process. And it may be that it was somewhat unsatisfactory, but the thing that I would so strongly point to, that whatever the doctrine is, whatever the way people refer to it and the way judges refer to it and law professors refer to it, I think it's indispensable in a democracy that they do constantly struggle with that. Once the court starts on a big question like one man, one vote or desegregation, haven't you then bought everything which our colleagues to the left say is inherent, which is the administration of the institution from there on that? Well, I don't think that's true. First of all, there used to be a doctrine that the court should try to avoid continuing supervision of a decree. That used to be quite accepted. You know, that courts recognized that it was unseemly for an appointed official with lifetime tenure or something approaching that to get involved in making these administrative judgments day by day as to how to run a hospital or a prison. In fact, what has happened over the last 30 years is judges no longer worry about it. You know, they get the case and they just go merrily on their way, and then it becomes fun to go around running all these institutions. Everybody's a secret administrator.
Professor Chase.
In the 1890s and early part of the 1900s, about 30% of the railroad trackage of the country was being run by federal courts in equity receiverships, and for exactly the same reason. Not because courts were very good at running railroads or because people thought courts should make policy about railroads, but because the people who ought to have been running the railroads were running them for their own benefit and not for the benefit of the shippers or the stockholders, and so they ran them into the ground. And as a result, you called in the courts for a while to reorganize them, hopefully, and to get them to the point where they could be turned back to the people who were supposed to run them and who would hopefully run them again in a way that, that comported with their legal obligations. Final point I'd like to make about the decree, again, is this business of courts rushing in to make detailed decrees, again, I have to say, does not comport with the facts. If you take the desegregation cases, for example, we had 12 years of Brown versus Board of Education, all deliberate speed, and so on, with never a busing order, never a compulsory desegregation order, with all of the cases culminating in orders in which the court said to the defendant school district, now you make a plan to desegregate. And we had 12 years of that with no effective desegregation before finally the Supreme Court in Green approved a compulsory order. The same is true essentially of these institutional cases. The court doesn't rush in with a decree. The court says to the administrator of the institution, you figure out a plan. You figure out how you can bring this institution into compliance with decent conditions. And the administrator doesn't do very much. And there's 6 months pass or a year passes and there are people in there in the same condition as before. And it's only after a considerable time in, I think, every one of these cases of a time with opportunity for voluntary compliance by the defendant, for the very reasons you say, that the court doesn't really like to get in this business, and they feel quite uncomfortable in this business.
The judges are no more immune than the rest of us to the blandishments of publicity and power, and I think it's foolish to think that they are.
Yeah, but the general kind of image of the courts taking initiative, reaching out, lusting for the chance to run one of these terrible institutions and try their hand at solving the problems can only be put forth by someone who hasn't litigated one of those cases. It's just not what happens. What happens is quite the contrary. What happens is tremendous judicial reluctance to get involved because they know that down the road of 5 years, 8 years, 10 years of an absolute entrapment in a web that there's no resolution to, and they want to divest themselves of those cases faster than you can imagine. That it just is exactly the opposite of the way you're suggesting. Once they get into it, something else happens. And what happens, I suggest, is that they learn about what's going on in those institutions. That the process that Professor Chase describes is typical of every one of these institutional litigation cases. They go on for years precisely because there is no effective mechanism of enforcing it and because the courts are relatively powerless to enforce their own decrees. And it's only at the tail end of those processes that the decrees start to get as intrusive as you suggest. And the alternative to that is no remedy. And the alternative to no remedy is no right. If you concede the problem with respect to the institutional violations, you're conceding 90% of the problem. That's where the judicial intrusion is.
No, but
that's where the judges are
I have
managing
mentioned
it.
dress codes. I have mentioned attacks on referendums, on open housing laws. I have mentioned local funding of schools. I have mentioned busing. I have mentioned a number of instances.
What you're dealing with in the nature of what you regard as the judicial outreach into the running of institutions takes place in the context of the kinds of gross mistreatment that occurs in all these institutions. If you concede that set of problems away, you are conceding 90% of the problem away. And that's the fact that I think that you're not coming to grips with.
Ira, I'm prepared to concede a point, although I don't concede your conclusion. I'm prepared to concede often that the judiciary starts down the process of extensive regulation of private institutions through the process of a decree.
State institutions.
Or state, and sometimes private. Sometimes private, too.
Universities that
Yes.
receive any federal
Well,
money.
but nowadays they're no longer private. But anyway, I mean both private and public. It starts down perhaps with some feeling of apprehension, trepidation, and some dim recollection that there are supposed to be restraints on judges doing that. And basically the problem, I would submit again, is a fundamental kind of judicial arrogance, the kind of arrogance that believes the legal process or the judiciary can resolve fundamental social problems. And that therefore, gee, I don't want to keep getting further and further and further into this organization, but damn it, I'm not going to stop until I get to the root cause. And that takes them, it seems to me, way beyond the capacity of the judiciary or indeed the tolerance of our society.
Well, I'm just suggesting that anyone who's been through one of those cases could not recognize your characterization of the way the judges proceed.
Well, I must say an important, difficult question was asked, and it's used up all the time we have. And this concludes another public policy forum presented by the American Enterprise Institute for Public Policy Research.
This public policy forum on the changing role of the courts has brought you the views of 4 experts in the field. It was presented by AEI, the American Enterprise Institute. It is the aim of AEI to clarify issues of the day by presenting many viewpoints, in the hope that by so doing, those who wish to learn about the decision-making process will benefit from such a free exchange of informed and enlightened opinion.
This Public Policy Forum series is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C. For a transcript of this program, send $3.75 to the American Enterprise Institute, 1150 17th Street Northwest, Washington, D.C. 20036.